Under what circumstances will a court require that a parent's possession of the child be supervised? This is a question I get in high conflict custody battles. It's an important question. And the answer is that it rarely happens. I would say that supervised visits generally occur in two circumstances. One, if there's a substance abuse issue, if the court is convinced that one parent has a drug or alcohol problem, then the court may order supervised visits until that problem is rectified. The second circumstance in which a court may order supervised visitation is if there's a history of abuse or neglect of the child. But it's important to note that supervised visitation is not permanent. I don't think I've ever had a case in which a court ordered that a parent's possession be supervised indefinitely or until the child is 18. And the reason for that is because the family code, it is the public policy of the state of Texas, as reflected in the family code, to encourage frequent and continuing contact between both parents and the children. So if, for example, there's a substance abuse issue, the court may impose or orders supervised visits, but provided the parent gets clean, if it's an alcohol issue, for example, the parent may be ordered to use a SoberLink device both before and during the parent's periods of possession, even if it's supervised. But if the parent can show progress and the parent can show that he or she has become sober, then the parent will ultimately transition off of supervised visits. With respect to abuse and neglect, the court may order the parent to take a parenting class or an anger management class, or order that the parent participate in some kind of therapy, sometimes a reunification therapy with the child. And provided there's progress there, then eventually the court will transition the parent off of supervised visits. I've seen cases where, frankly, I think judges have been too lenient or have moved to transition away from supervised visits too quickly. But again, the law is very much in favor of promoting a relationship between both parents and the children. Now, obviously, that can be a little more challenging and a little more complicated when you're dealing with older children who may just refuse to engage in visits, who may refuse to go on visits. And in a situation like that, then the court is more limited in terms of what it can impose and order a child to do. But again, supervised visits are not intended as a punishment. They're not intended to be something that is permanent. It is a temporary measure to ensure the safety of the child while the other parent works to address whatever issues he or she is dealing with that pose a risk to the child.